Hi everyone, hope you're having an amazing day. In today's video, I have an update to share with you regarding the EB-5 investor visa program. USCIS has come out with its response to the recent court case which lowered the EB-5 investment amount from $900,000 to $500,000. In this video, I'm going to share with you the details about USCIS's response and what this means for you if you're planning on pursuing an EB-5 investor visa. So make sure to stick around. Hi everyone, my name is Michael Ashoori and I'm a US immigration lawyer based in Los Angeles, California. At my law firm, we work with clients from all 50 states and worldwide, and we regularly post videos to make sure that you're up to date with the latest immigration news and trends. So if you haven't yet subscribed to our YouTube channel, make sure to hit that subscribe button now. So as I mentioned in today's video, we're going to talk about an update regarding USCIS's official response to the recent changes to the EB-5 investor visa program. So to start off, let's give a quick background about what the EB-5 program is and the recent news that's developed over the last few weeks. So basically, the EB-5 investor visa is a green card option for investors, where an investor can get a green card for themselves, their spouse, and their children based on making an investment in a US business and creating jobs for US workers. Now, historically, for several years, the required investment amount to qualify for an EB-5 visa was $500,000 on the low end. And back in November of 2019, the required investment amount increased to $900,000. Well, when the investment amount went up, a company by the name of Bering Regional Center filed a lawsuit against the Department of Homeland Security, alleging multiple things that were improper with this increase in the investment amount. Well, on June 22nd, just a couple of weeks ago, the federal judge overseeing the case sided with the plaintiffs and agreed that there were procedural errors which took place when the Department of Homeland Security enacted the rule back in 2019, which increased the EB-5 investment amount. So the judge set aside those changes which increased the minimum investment amount from $500,000 to $900,000. Now, when this happened, it was wonderful news for thousands and thousands of prospective EB-5 investors, because as you can imagine, when the investment amount increased, it had a chilling effect on the EB-5 program, because many people were doing all that they could just to put together enough funds to get the $500,000 required to get an EB-5 visa. And when the investment amount increased to $900,000, it was out of reach for many thousands of investors that once could have potentially applied for an EB-5 visa. So that's all the background information. Now I want to tell you about the update for today's video. Back when the news broke on June 22nd, when the news broke that the federal judge invalidated the 2019 rule, it was still unclear for some people what this really meant. People had questions regarding whether USCIS would accept these changes, whether USCIS would still require investors to make a $900,000 investment. There were many questions, and people were waiting to see how USCIS responded to these changes. Well, USCIS has officially updated its website with a response, and I'm going to share that response with you, and then we'll discuss it. So take a look at my screen and let's go through this response together. So as you can see, we're on the USCIS website on the web page devoted to the EB-5 Immigrant Investor Program. And as you can see at the very top of this page, there's an alert, and the alert reads as follows. On June 22nd, 2021, the U.S. District Court for the Northern District of California in Bering Regional Center LLC v. Wolf vacated the EB-5 Immigrant Investor Program Modernization Final Rule. While USCIS considers this decision, we will apply the EB-5 regulations that were in effect before the rule was finalized on November 21st, 2019, including no priority date retention based on an approved Form I-526. this is key right here. This second bullet point is very key. The required standard minimum investment amount of 1 million and the minimum investment amount for investment in a targeted employment area, TEA, of $500,000. Third bullet point says permitting state designations of high unemployment TEAs. And the fourth bullet point, prior USCIS procedures for the removal of conditions on permanent residence. And now this is where it really gets summarized here. It says, in other words, we are applying the regulations in effect before November 21st, 2019 on this website and in the USCIS Policy Manual, Volume 6, Part G, Investors. In addition, we again will accept the April 15th, 2019 version of Form I-526, Immigrant Petition by Alien Entrepreneur, because the November 21st, 2019 version of the form reflects updates from the now vacated rule. So as you can see from what we just went over, USCIS has made it clear that for the time being, they will be accepting EB-5 investments for the reduced $500,000 investment amount. So this is wonderful news. Again, as we talked about, there was still some question. Some people still had doubts about whether USCIS would be accepting EB-5 petitions at the pre-November 2019 investment amount. Well, what we've just seen from the USCIS website is that USCIS has confirmed that for the time being, they will be accepting EB-5 petitions at the reduced pre-November 2019 investment amounts. Again, this is wonderful news for thousands of EB-5 investors who now have the rare opportunity to pursue a green card through the EB-5 program at the reduced pre-November 2019 amount. However, with that said, there are still some very important details that I want to share with you. The first thing that I want to share with you is that it is very likely that this window of time where prospective EB-5 investors will be able to qualify for the pre-November 2019 investment amount will be a limited window of time. And without going into too much detail, back on June 22nd, when the federal judge invalidated the rule which increased the EB-5 investment amount, the judge did not prevent the Department of Homeland Security from correcting the errors that it made when it promulgated the new rule which increased the investment amount. So basically, the judge left it open and left it available for the Department of Homeland Security to reenact that rule which increased the investment amount and to do so properly and to correct any problems that were in place when they first enacted the rule. So again, it's very likely that the Department of Homeland Security will reenact the rule which increased the EB-5 investment amount. So for that reason, it is very likely that this window of time where people can qualify for an EB-5 visa based on making a $500,000 investment will be limited. This is likely not going to be something that is extended indefinitely. Now, you might be wondering, how long do I have to qualify for EB-5 based on a $500,000 investment? Well, nobody knows for sure, but to be on the safe side, if this is something that you're considering doing, it's probably a good idea to act sooner rather than later. Now, the second important update that I want to share with you is that the EB-5 Regional Center program has now lapsed. So there are two types of investments to qualify for an EB-5 visa. Somebody can invest by making a direct investment, or they can make a regional center investment. Well, the regional center component of the EB-5 program has lapsed. So right now, for anybody considering an EB-5 visa, the only available option for the time being is a direct investment. Now, there's a lot of details about the difference between a direct investment and a regional center investment, but for the most part, a direct investment is any type of an investment that is made into a business that is not a regional center. So if you go out and start your own business and invest in your own business, or if you purchase an existing business, or if you partner with somebody to do a startup of some kind, you're very likely going to be falling into that category of direct investments. And lastly, one more important point that I want to share with you is that in order to qualify for a $500,000 investment, you must invest in a targeted employment area. So a targeted employment area is an area that's either experiencing high unemployment or is designated as a rural area. And in order to qualify for the $500,000 investment amount, the business that you are investing in must be principally doing business within a targeted employment area. If the investment is made in an area that is not a targeted employment area, then the investment amount is $1 million. And again, this is how the rule was pre-November 2019, but I just want to make that clear for anybody that might not necessarily know that. So there you have it. In today's video, we talked about this brand new update that USCIS has updated on its website that they will be accepting EB-5 direct investment petitions at the reduced $500,000 investment amount. Now, this is going to come as welcome news to thousands and thousands of prospective EB-5 investors. If you know anybody that can benefit from this information, please make sure to share this video with them. We're all about empowering you with knowledge. So the more people that can watch this video that can benefit from this information, the better. As always, thank you so much for tuning in, and I will see you on the next video.